All right. Great day to you. This is Courtney Rollins with the Life in Transitions Experts podcast, the host as well as owner operator of Estate Pro Service and Do REI Deals, where we help folks navigate the probate process and solve problems and create income and wealth through the power of real estate. On this in this podcast or on this channel, this page, I try to give as much information as I can that helps people think about their estate planning, as well as provide solutions and to or resources to issues that come up with the property. One of the hats that I wear is a real estate investor and a wholesaler, and quite often I can find properties and opportunities by helping people in this space. And so, one of the things that's a very powerful tool or legal instrument that you can use to avoid probate in many times in many places is a trust. And today we're going to talk about what a revocable trust is and what goes in it. Disclaimer, I'm not an attorney. I'm not a financial advisor. I'm not attempting to play one on my YouTube channel. I'm just sharing my experience and hopefully it will be helpful to you. But definitely consult an estate planning attorney if you decide to go the route of any type of trust, particularly a revocable trust. And if you do need an attorney, reach out to me because I am connected to a nationwide group of vetted estate professionals that can serve and can help you. This conversation is very timely for me as well because later on today, this afternoon, this evening, my wife and I are sitting down with an advisor, with a counselor, to take a look at trust and our will and all that good stuff because we want to make sure that we have our estate plan put together comprehensively and that it's reviewed so that it's up to date with our current wishes. It's an awesome thing to do, folks. Gives you the opportunity to leave a legacy and to have some security legally regarding what that legacy is. So there's basically four parts to a trust, and let's take a look at them. All right, let's get into it. The first one, come on, buddy, is well, not necessarily in particular order, but there's the grantor, there's the trustee, the beneficiary, and the trust asset. So the grantor is the person who creates the revocable trust, and they also are the ones who transfer the assets into in there. The grantor gets to maintains control over the trust and can make changes or revoke it at any time during their lifetime. So quite often, the person who owned previously owned the property or the assets that are going into the trust is usually is the grantor of the trust, and they have control. The trustee is the person or responsible for managing the assets held in the revocable trust. Now, quite often, the grantor is also the initial trustee, but there are successor trustees that can be named to take over the responsibility, particularly if the grantor dies or is incapacitated, and you can have a series of trustees that are for um, maintaining and managing the trust. Very important to have. Another is the beneficiary. These are the individuals or organizations that will receive the trust assets according to whatever the grantor's instructions are. This can include family members, friends, or charities, or any other, design beneficiary. So you're starting to see the real benefits, I assume and hope. And you may ask, what's the difference between this and a will? And we'll talk about that in a few moments. But let's look at the fourth component of a revocable trust, and that is the trust assets. So those are the things that's placed in there, whether it's real estate, it could be a bank account, it could be investments, it could be businesses, personal property, other valuable assets. Anything that's transferred into a trust can be part of the trust and can be managed by the grantor's wishes. All right. And so that's very important to know. One thing about it, if you do put something into a trust, make sure that it's publicly recorded. There's an analogy that folks use sometimes where they say it's like taking all your belongings and put it into a safe, but never locking the safe if you don't get it recorded. So that means transferring the actual ownership title of these assets into the trust name. So let's take a look at least five things you need to think about or look at when you are think about some important parts of that trust. One, the actual trust agreement. This is the legal document that establishes the revocable trust and it outlines the terms and conditions. It includes information about the grantor, the trustees, the beneficiaries, and how the assets are distributed. So that's important to have the document, obviously, right? You got to have the document. Two, you need to be able to fund the trust. That means putting actual assets into there. This process is known as funding it called. That's where it includes changing the title so that it's recorded, so that we know that, hey, this property is no longer owned by Courtney Rollins. It's owned by uh, Purple and Gold Trust or Rollins Trust or whatever name you want to put. Sometimes people put their name or their family names into a trust. Sometimes they don't. It depends on. There's discrepancy about whether or not the trust gives you a level of anonymity. I hope I said that name right. That's one of those names that scare me, but it gives you a layer of just discretion as far as who can see who owns the trust. But sometimes people again have their family's name on there just to make it easier. Another thing that's important about the trust, number three, is that it is revocable. Uh, there are tons of different types of trust, but one other type that you may have heard of is irrevocable trust. And as you might know by the name, it's it's not revocable, but a revocable trust can be changed at any time during the grantors by the grantor during their lifetime or whoever the grantor is. It's flexible and allows for changes as circumstances change. Also, what's great about this trust is that there's an incapacity plan. Some people even call it a living will because if you're still alive and you become incapacitated or the grantor becomes incapacitated, and the grantor is unable to manage the affairs, then the successor of the trust can step in and handle the estate, there's the trust assets on their behalf, which makes things a lot easier legally and saves in time, um, saves in headache, and there's clarity as well. And one of the most strong benefits about a trust is that it avoids the probate process in North Carolina if it's properly funded. If the titles are properly transferred over, it can help you avoid the probate process because probate is all about handling the affairs, the assets of a deceased person. But the deceased person doesn't own that property or that asset anymore. The trust owns it. Now, that person may have been the grantor or the beneficiary or uh, the trustee or whatever the terms are, role they played in there, but they are not officially own the property. So there's nothing for that's not, uh, can't go through probate. So it's one of the best things about that. All right. If you do need support thinking about setting up a trust or anything, again, I'm not an attorney, but I do have great attorneys on the team that we're a part of the same team. I can connect you with. If you need help with the probate process, reach out to me as well. It's my mission to help people through the probate process, particularly if there's property or that you need support with. If there's not property, we still let's sit down, see if I can point you in the right direction and help you out. Other than that, I hope you found this helpful. I'm about to send this straight to my wife so that she can take a look at this before our meeting today. And I'm excited about making sure that my legacy is secure. And I hope that you are too. This is Courtney Rollins with the Life in Transitions Experts podcast. Let your light shine. Cheers.